Hi, and welcome back. This is part 3 of raising a charter question or a notice of constitutional question before an administrative board, tribunal, or commission within Ontario. As I keep saying, as I've said before, this isn't legal advice. You should search out legal representation and seek legal advice whenever possible. I understand many can't afford it, and that's reasonable. But I still have to let you know you should always consult with a lawyer, paralegal, depending on your jurisdiction for advice on doing anything. Also, it's important to note that this is only specific to Ontario in the sense of how to do it, and the reason why I say that is because the forms are slightly different. We're going to get into doing the forms in this episode, and the forms are different from each province. Why, I don't know, but they are. And more importantly, some provinces don't give the board or tribunal jurisdiction to hear constitutional issues, whereas within Ontario, the WSIB, the Workers' Compensation Board, and the tribunal, the WSIAT, do. So this is where I'm focusing on. Now, it's not hard to find out and do a little bit of research on the forms and how to raise a notice of constitutional question in your province. It's also not hard to find out if that board or tribunal hears notices of constitutional questions. Simply just call them and ask them. Or you can go to their website, usually it's probably got a lot of information, or you can send an email to inquire. Okay, so let's move on. How to enforce your rights. In Ontario, as I said, if you wish to claim a remedy under Section 24, what you specifically have to do is prepare, serve, and file a notice of constitutional question, which is called a Form 4F in Ontario's Rules of Civil Procedure. Sorry, that procedure should be capitalized. Again, like I said, I apologize. There is some spelling and grammar mistakes. I did proof it, but I didn't proof it enough. At any rate, this is a form that's on the website, and it's on. You just Google search Ontario Rules of Civil Procedure Forms, and it's like 5th or 6th one down from the top. On it, the government did a really good job, and they provide all the different legal forms for different filings within the Superior Court of Justice. Now you'd say, well, wait a minute, Paul, why am I using this form from the Superior Court at the WSIB at the tribunal? The reason why is because they don't have the form, and instead of creating one, they were just like, we'll just use, why reinvent the wheel? Fine. I mean, in some ways, it's easy for them and people, but at the other time, in another way, it makes it a little bit difficult for people that don't know this or don't know how to do this. So what you have to do is send a copy of the actual notice of constitutional question to the Federal Department of Justice and the Attorney General of Ontario. You have to do this because this is a requirement under Section 109 of the Courts of Justice Act. If you don't do that, then your notice of constitutional question cannot be heard by whoever it is, the board, tribunal, or the court. They won't hear it, or if they do, and then the Attorney General or Department of Justice finds out, they can have your issue appealed and, if necessary, overturned. So as I was saying, it's a Form 4F, and you can get it on the Rules of Civil Procedure website. I said you can Google it, but I've provided the website there for you. In the form, it says at the top, Form 4F, remove that and insert the general heading of the proceeding. This is the name of the case. Again, apologies for the spelling mistake. So in other words, this would be you versus your employer, not the board, if you're at the tribunal or anyone else. Here, as you can see, I've provided an actual copy of what the top of your notice will look like. I used James Bond and MI6 as a fictitious injured worker and employer. At the top, I started with the claim number 007. I would put at the very top above Workplace Safety Insurance Board is in capital letters Ontario. Just one mistake I made in that. Then between is on the left, you leave that way. Then James Bond, you put your name in capitals. Then on the right side, you're the requesting party because you're requesting whoever to look at your notice of constitutional question. You're also, generally, I added in appellate on appeal, so they know that this is going with an appeal, whether it be to the WSIB appeals branch. And that's another thing too is going back to the top is where it says Workplace Safety Insurance Board. I would put underneath that Appeals Services Division as well, to be specific, because the operating area and the Appeals Division are two separate things, and you want to make it very clear. Getting back to it, is that normally you would file this with an appeal. So you want to make clear who you are, is that you're an appellate on appeal, and also you're an injured worker. You don't have to put in the injured worker employer part, but I would, to identify it, make it very clear. That way they can easily deny it because you're an injured worker. No, just kidding. Then you put the employer's name in caps. They're the responding party in this request, or respondent. I would just say responding party, respondent on appeal, and then accident employer or just employer. Your choice, it doesn't matter. Then, as you can see, this is where it changes. You say the requesting party, Mr. James Bond or Miss Williams, whatever, intends to claim a remedy under Section 24(1) of the Canadian Charter of Rights and Freedoms. So what is it? So meaning that Section 123 of the Workplace Safety Insurance Act is an infringement of Section 15? Or is it that the decision of the adjudicator is an infringement? Or is it the failure to do this? So it's whatever we talked about earlier. Remember when I was talking about the different remedies? So you're saying their conduct or their law or their policy is an infringement. Then I said Section 15, but remember I reviewed with you the different sections of the Charter. So you can say Section 2 if they harassed you because you did a protest and said you can work. Section 7 if whatever they did infringed your right to life, liberty, and security of the person. Security of the person is an interesting part because you can argue under that right of autonomy if they're denying your healthcare benefits or forcing you to undergo a healthcare procedure. I would also argue that it's an infringement under the UN Declaration of Human Rights, because you could argue it's government doing health experiments or something. This you would have to do more legal research on. Then it says proposed method of hearing. Now in the original form, when you look at the form, it will say oral, video conference, whatever. And then it will say a date and time. Normally you would do this, you would call the court and say, I'm filing this motion, can I have a date when you hear motions? This is just like a motion. And they would say, yeah, we do it every Tuesday. So then you say be heard on Tuesday at 10 a.m. or shortly thereafter. In this situation, you don't know when, so then you would say the notice of constitutional question is to be argued by method and at a place and time to be determined by and in this case, the WSIB's Appeals Services Division, or if it was the tribunal, the Workplace Safety Insurance Appeals Tribunal, right? So that way it's easy to deal with. The next thing you're going to do is you can put in material facts giving rise to the constitutional question. So what you want to do is just very, very briefly is describe what you're claiming, meaning like what happened and why. And you want to just state the facts like so-and-so James Bond is an injured worker as a result of work injury on this date. James Bond claimed health care benefits, and then on May 5th, the adjudicator denied health care benefits. In doing so, infringed Section 7 or 12 or whatever of the Charter. You are, in effect, in a way, making a legal argument, but I would just leave off the in doing so. I would just say lead up to what is it? So when somebody briefly reads this, they understand your story. But it should be just very quick. Point 1, point 2, point 3, that's it. Fact 1, fact 2, fact 3, that's it. Make your legal arguments either in person at the hearing, or you can do what's called as written submissions. And in another video, I'll talk about written submissions. This is the next section on the form that you do. Another point that, actually I'm going to go back there, sorry, is when you're making your statement of facts, number the paragraphs. You don't have to do double spacing like I did here. You can do single spacing, but always make sure your paragraphs have a space between each one and they're numbered, so that way it's easy on the eyes. Oftentimes, injured workers or people will send me correspondence and it's just one long paragraph. It's like really bad. It's hard on the eyes. It's hard to read. So it's really important to give physical structure to your document. And one way is numbering the paragraphs. The reason why legal documents, judges' decisions, legal arguments, affidavits, everything is numbered is so when somebody's referencing it, they can say, well, yes, paragraph 2 of your notice of constitutional question said this. So now you can know, and you can look and you go, oh, paragraph 2. So you know exactly what they're talking about. So sorry, going back to the legal basis. Now, another point is when you're numbering the paragraphs, don't renumber them for each issue as you saw, because this is a new heading, which is legal basis for the constitutional question. Carry the numbering on. I do that in this situation for the main paragraph numbering. The sub-paragraph numbering, meaning 2A, 2B, 2C, those I renumber for each number, right? So it's easier to understand, right? It's just, a lot of it's just common logic. But at any rate, in this section, you would put your legal basis for them to hear your question, you know, your issue that you have, right? And you usually start off with the biggest one, which is section 52, saying that the Constitution is the supreme law, meaning that the Workplace Safety Insurance Act or the Workers' Compensation Law or their decisions or their policies are not stronger than this. This is stronger than them, although they think it is, but it isn't. And then you go on, and I would talk about section 24, which gives you the right to claim a remedy. Now, it says a court of competent jurisdiction, as I said earlier. The Supreme Court in Nova Scotia v. Martin made clear a court of competent jurisdiction can be a board or tribunal if they have the power. Then I would just very briefly reference the sections of the charter that you're intending on relying on, saying that the law, the section of law, or the decision or the policy infringe section 2 or section 7 or section 12, whatever. Just state the section and its meaning. You know, section 7 of the charter provides a person's right to security of person, liberty, and all that stuff. Section 15, right to equality. Also, I would mention the board or tribunal's legal authority to hear it, which is that the blank considered to be a court of competent jurisdiction and thus authority constitutional question. You could actually reference this section of law, or if there isn't any, and that means they haven't had the right taken away to do this, their authority, I mean, then just reference Nova Scotia v. Martin in the paragraph. I think it's in the very beginning. I can't remember what section, but you would just say that the Supreme Court determined that boards and tribunals within Canada have the authority to hear a constitutional question, and then you just cite it, and it's very quick. Then you end that with the date on the left side. I put January 1st, 1915, because that's when the first Workers' Compensation Act came in, just jokingly. You put your name, your address, your city, your province, postal code, telephone number, email, so they can reach you. Then what I do as a title is I say self-represented litigant, so they're aware. You state you're the requesting party and appellate. You could even add in injured worker. It's important to remember something as a self-represented litigant. Never, ever, ever take legal advice from a decision maker. It's actually a very serious breach of the rule of law. And the reason why is because it causes them to lose their impartiality. And it's important that you respectfully remind them of that, saying, you can't give me legal advice. You can give me procedural advice. So when you go into the court, you'll find clerks doing this, and they're right. They'll say, I can't give you legal advice. I can't tell you if you have a case or not. That's legal advice. I can tell you legal process. This is the form you use. That's the court you go to. That's it. Oftentimes, I've had judges, decision makers, and even lawyers of opposing side giving me unsolicited legal advice, and in fact later found out to be wrong. This is a dangerous situation for boards and tribunals, especially tribunals, because they should never be giving legal advice, even though they want to help. because they might be thinking they're helping, and believe it or not, they actually make things 10 times worse. In my own personal case, the tribunal panel members gave me legal advice repeatedly throughout the hearing. And again, I'll get into that in another video. Advice that I felt, and this is the problem, you feel compelled to follow, because if you don't, you feel they'll rule against you. That's why decision makers should never, ever, ever give legal advice. You know, this is why it's important, and I don't understand why an injured worker shows up at a tribunal or board self-represented and has no help. Remember, the workers' compensation system is privately funded, so they have the money, they have the resources. For example, in Ontario right now, in 2022, they have close to $30 billion surplus fund, the unfunded liability they call it. This year, they just gave back $1.5 billion. So you tell me they can't have like a lawyer, paralegal at the tribunal to help self-represented people prepare their case and show them how to argue it and that stuff? It's not that they can't afford it, it's that they don't want to. And that's the problem. And a part of the reason why they don't want to is because of the cost, because the legislature is cutting their budgets so they can give all the money back to employers. Another argument of why maybe workers' compensation should be federal. Sorry, on a rant again. Okay, so then the last part of this page is then what you do is you would address who you're sending it to, and you have to send it to the employer, who's the opposing side. You also, as I said earlier, you must address it to the Attorney General of Ontario and to the Department of Justice. Now, the nice thing for convenience is when you serve it on them, you don't have to do it like a court document, go to them and give it to them. The nice thing, because of COVID now, believe it or not, COVID was actually a good thing for the legal process in some ways, where now the WSIB and tribunal, or all the WSIB sends you your files by PDF now. They do a lot of things electronically. Some hearings are heard by Zoom. I'm not comfortable with that. In the case of courts, they'll hear motions and appeals by Zoom because it's just legal arguments. That I agree with. But hearing actual physical oral testimony, I think it should still be in person, because you need to see that person to see what they're saying. You know what I mean? A video just doesn't do it. I mean, there's so many problems. Like, for example, you don't know as a representative or even a self-representative when you go to cross-examine a witness if they have somebody on the other side of the camera coaching them. You might go, no, believe you me, it happens. And it raises concern about the quality of testimony. But this is a system that the administrative boards and tribunals have moved to, and it's not like they seem to be too concerned about it right now. The final document that you use, and this is optional, this is in Superior Court, Court of Appeals, Supreme Court of Canada, and it's called a back sheet. And the reason why they use it is the judges like it is because then it gives the information on the back. It's like a back page of a book. And it gives the information. You can see the two parties. MI6 should be over top of responding party. That was a little goof up of mine. On the right side, it shows the claim number. It also shows the forum, or what I call is the forum, the legal forum, which is the Workplace Safety Insurance Board. And of course, I spelled workplace wrong. That was a typo. It's not a spelling, it's typo. I'm bad with typing. And also it shows the proceeding of where it started. So in this case, it'd be 200 Front Street, Toronto. That's where the WSIB is right now. Apparently, they're moving to London. Ironically, that's because where the president of the WSIB is, if you can believe that. This is how insane the workers' compensation system is. Oh, I'm president now and I live in London. Okay, let's move it to London. And then put your name and address at the bottom. The reason why you leave this big box on the left clear for courts is so judges can write out their endorsement. I actually have endorsements from judges who did that. They just photocopied the back sheet. They wrote their endorsement on it. And then it's actually part of a book. And they'll write their endorsement. And then it's filed with the court. Then the clerk, they just photocopy it and send you that written endorsement. Now, the boards and tribunals, they don't do that. But it's just nice. You know, if you want to give it to them, you don't have to. It's totally optional. In fact, a lot of the stuff that I'm talking about, well, not a lot of it, but some of it, it is optional, right? Maybe eventually I'll talk about how to make a written submission and break it down into making your statements of fact and what is a statement of fact. People will say, well, I was this. No, making a statement of fact is, for example, Mr. Taylor was injured on February 6, 1997 when a load fell on him. And then what you do, that's a statement of fact. And every fact you reference with evidence, whether it be an oral statement. So when I make submissions to the appeals board or tribunal, I say oral evidence to be provided by the injured worker, Mr. Taylor or whatever, or I'll reference, in the case of a motion or something, you reference an affidavit, right? And then on top of that, so you have an affidavit, a sworn statement, so you got your oral evidence. So that's one. But then more importantly, what you want to do as much as possible to build credibility in your appeal is you want to back up your oral statements with physical evidence. So for example, when you say to the person, I was injured on February 6, 97, in your affidavit, you do what I use footnotes, meaning it's a little superscript that's on the last part of the sentence, and it'll say like 1, 2, 3, and then at the bottom of the page it says, for example, see employer's report of injury dated February 10th or whatever, located in whatever, right? And then they see that what you're saying is credible. You see, and that's very important. Then when you talk about diagnosis of injuries, oh, Mr. Taylor was diagnosed, or I was diagnosed with a low back, mid back, upper back, neck, head injury, right? In your statement of fact, you would basically copy that over and say, Mr. Taylor was diagnosed with this. And then you'd say, affidavit or oral statement by Mr. Taylor and reference to physical evidence. So they might not believe your oral statement, but they have no choice but to believe the physical evidence. Now, you'll get them where they're weighing physical evidence and saying, yeah, this doctor's thing is okay, but then there's 3 or 4 medical reports showing the opposite. And sadly, it seems to me in my experience, and I mean, it's troubling because I find in the boards and tribunals and weighing evidence is you have 5 pieces of medical evidence proving your case equal in weight, and they'll have 1 against it, and they'll rule against you. And when weighing evidence, when you look at the scales of justice, that's how a decision maker is to decide the facts of a case. Were you injured on January 1st, 2000? Oh, there's the report from the employer, there's the report from the worker, and there's the doctor's report, all showing that. Moreover, the employer didn't question it. So the evidence is overwhelming that you were injured on that date and you injured your back or whatever, or your leg or whatever, right? In weighing the evidence, that's 4 pieces of evidence. But what if the employer's report says you injured your back and neck? The worker's report shows that. But say 2 other reports don't show it. Now you have 50-50 evidence. In that situation, according to the law, it says benefit of the doubt. See, in civil cases, in weighing evidence, a decision maker or a person must prove on a balance of probabilities. Basically, in percentage terms of understanding, is 51% of the evidence proves their facts or proves their case. In workers' compensation, benefit of the doubt is 50-50, meaning if the evidence is equal for and against, it goes to the injured worker. Therefore, if you have these reports and this evidence showing equally and against of the injury, then you should get entitlement for the injury. The problem is the boards and tribunals always state balance of probabilities, and they're wrong. That, to me, that's an error of law, even using that term at all. I even argued with a law professor and saying the standard of evidence weighing is not balance of probabilities, it's benefit of doubt, 50-50. To be more clear on weighing of evidence as well, this is another thing I'm just quickly ranting on about, is in criminal law, people will say, well, Paul, why don't you bring a criminal charge? The reason why I don't bother with the criminal court at this time is because the weighing of evidence has to be beyond a reasonable doubt. So in other words, 80-90%, really high level. And you want that high for criminal, because you don't want people convicted of murder basically on a very flimsy weighing of evidence, right? So it's a very high threshold to prove. Whereas with seemingly, where civil court is balance probabilities, 51%, to me, personally, in my experience, it seems like the evidence has to be the level or threshold of criminal court beyond a reasonable doubt in dealing with workers' compensation matters. The boards and tribunals will often cite the privative clause, and that would be actually another video that I'll talk about, where they say that, Ontario, for example, has a very strong privative clause, and they're right. But where they're wrong is the reasoning behind the privative clause. You see, Justice Meredith argued, and it says it in Butterworth, which is a legal reference book, clearly says the privative clause is not to protect the employer, the board, or tribunal's decisions. It's there to protect the injured worker. And the reason why is so employers can't repeatedly challenge decisions of the board or the tribunal. And the reason why is because they have unlimited resources. I mean, talk about, for example, Walmart. Tell me they don't have the money to hire the best lawyers and to fire off repeated appeal after appeal. Tell me Canadian Tire doesn't. Or Stelco Steel, or all these other big corporations with millions and billions of dollars. And this was the reason of the privative clause. It was not meant to prevent injured workers from going to the courts to protect their rights. In fact, the board, the tribunal, and employers do not have rights. And I argue this because the Supreme Court of Canada made clear that businesses and government don't have rights in R.J. MacDonald v. Canada. They said people do. So in looking at the privative clause, I believe the courts have it completely wrong, that they should be not using it against injured workers, but using it to help them. And I think this is something that's got to be further explored, and I'll look at this in future videos. So this is the end of this video. I hope you learned a bit about it, and I'm sorry if I didn't cover every single aspect, but you're dealing with constitutional law, charter law. I literally took university courses just on the subject of charter law, right? And even just there's whole courses, university courses, just on certain sections. To cover everything in one video is pretty much impossible. So you're gonna have to do a lot of your own research and learning as well if you need to bring constitutional questions. But to help you along, to move the process quicker, if you're in Ontario, what I'll do is I'll post in the comments of this video a link for you to download the sample files that I referenced, which would be the notice of constitutional question and the back sheet if you want to use them. I'll give you a PDF copy, and I'll provide a Word document copy so you can just type in the information and it's quick and easy. But again, don't be lazy and don't be sloppy with it. Take your time, formulate your arguments. When you file your notice of constitutional question, think how your issue, don't just say it is a violation. Prove it. Say you infringed my Section 2 rights because you said that I can return to work simply because you saw me in a protest. That violates me in the sense of association, freedom of expression, and so on, right? And that is a very clear and a very well structured argument. You get more into it later, but that's how you would bring it in that situation. In the cases of age and disability, these become very complex arguments because not only is it an injured worker issue, it's a bigger issue under Section 15 of the Charter. Currently, the courts look at tests, and that's another thing you're going to need to know about is a test. A test is what you need to meet to claim an infringement. For example, Section 7 has a two-part test. What part was infringed? Right to life, liberty, security of person. And then, was that infringement justified, or was it done in the principles of fundamental justice or whatever? You have to do that as well. That's in making the actual arguments. Section 15, the test is spelled out in Law v. Canada, a Supreme Court of Canada case, which was a two-part test. And you have to prove which ground meeting is it stated in the Section 15 disability, age, whatever, and then is the conduct discriminatory? And if it is, then you can claim an infringement. Then remember too, you also have to argue against their Section 1 argument that discrimination is justified under Section 1. So like I say, this is a very complex thing to do, but if you have no representation and you have no money, which is the real reason of self-representation, oftentimes judges and decision makers get very rude and very arrogant with self-represented people because they think we're arrogant and we know more than a lawyer or paralegal, when that's not the case. It is simply based on poverty that they're the reason why they're there. In fact, I recall in reading a research paper conducted by the National Self-Represented Litigants Project, who had said that a lawyer who was representing himself was chastised by the judge. This is not a good thing. A justice system, including administrative justice, which is what workers' compensation systems fall under, must be a fair and equal system. So that way, when the person walks away, they may not agree with the decision, but they can say that it was a fair decision, meaning that the decision followed the law, followed the facts. In the majority of decisions I've seen in workers' compensation, including the constitutional ones, I can't honestly say that, which really concerns me. Because as I say, I believe there's an inherent stigma or hatred towards injured workers. That, here's a good example. In the one case when I was appealing the decision to dismiss my civil lawsuit against the board and tribunal in Ontario, I'll never forget the words of the Court of Appeal when I went to start my arguments. And the president of the panel is what they call it because it's 3 judges. He said, well, this is workers' comp, you're an injured worker. This should be judicial review. He wasn't even interested in hearing my arguments. He'd already literally, by that comment, made up his mind. You see, and the mistake later I found out is that, yes, they're right, is you can't sue for benefits in their argument because we have the appeal process. However, when you're claiming that your rights were violated or that they did gross negligence, serious wrong, then in that situation you can claim, you can make a civil claim for damages. And the Supreme Court in what's called as Telezone v. Canada actually said that a person, if they have to go through the administrative appeal process first, win, then sue for damages, that is what's called as a denial of access to justice and can't be done. But yet, amazingly, I would not doubt that the Supreme Court and the courts would say, yeah, that's for everybody else. For injured workers, it's different, which creates a stereotype and an actual infringement under Section 15 of the Charter. But unfortunately, this is the fight we have to deal with as injured workers. We have to not only educate, but we have to be aware of these stigmas, these issues, so that way we can respectfully teach others how to recognize and deal with injured workers in the proper and the right way. As they say, justice for injured workers, not just justice for workers, but justice for all. And workers' comp is a right, not just a privilege. Oh, and by the way, please subscribe to my YouTube channel below. It's really important for me that you do, because the more subscribers I get, I'll be able to change and properly name my channel, which is what I want to do. Don't ask me why YouTube does this, but they do. So I hope you enjoyed my short video series on raising a constitutional question or a charter question. And I'll be making more videos on more issues, and I'll probably revisit the charter question thing in the sense of how you would make good arguments for, like, say, a Section 2 breach, a Section 7, a Section 12, and Section 15. I'll show you how to formulate your arguments and back them up with good facts and verified evidence. So I hope you enjoyed this, and I hope you look forward to more of my videos. Have a great day, and don't forget to fight for your rights.